Hello, everyone. This is Tom Fox back again with Jonathan Armstrong for another episode of the award-winning Life with GDPR. Welcome back, Jonathan.
Thanks very much, Tom.
Jonathan, the topic of chief compliance officer or sort of chief officer liability comes up from time to time. It has come up in the anti-corruption compliance space. It has come up in the regulated industry compliance space. You have previously looked at it in the technology space and in the cyberspace. We've had the opportunity to visit with that on that topic on our panel podcast, Everything Compliance. So I thought maybe I could ask you to take a look at some of the most recent cases that have gotten your attention and either consider them from the framework of a potential CISO or CCO liability, or if not, what were the factors that maybe led to no liability or at least not even a prosecution? Do you want to start with Joe Sullivan or somewhere else?
Yeah, let's start with Joe Sullivan. I think from my point of view, I think it's one of those topics whenever you're sort of, if you like, trying to predict the year ahead at this time of year and thinking what is one of the trends that we're likely to see, then I think personal liability is likely to be one. And that's because a lot of prosecutors love it and a lot of politicians seem to love it as well. There's always that sort of theory that if you make an example of one or two individuals, that others fall into line, and that in some cases, finding the corporation isn't the right answer. And that might be because they just regard it as a cost of doing business, or in some cases, it's because you're harming the victims. For example, we've had cases where there's been data breaches from mutual associations where you're obviously taking the members' capital out of the business to pay the fines, so you're hitting them twice. So I think personal liability is a clear trend to watch out for 2025. And you're right that CISOs, chief compliance officers, are in the frame for that. So to start at Joe Sullivan, as you suggested, for those of you who don't know, Joe Sullivan was the CISO at Uber. He was also an experienced lawyer. He had a bug bounty budget for people who could point out if there were issues in their software. And he had what was effectively a ransomware threat and decided to pay the threat actors $100,000 out of the pre-approved bug bounty payment. And the prosecutors said that he wasn't clear about doing that, and he faced a DOJ prosecution in the US. He ended up being convicted, but getting a sentence of 3 years probation because of his good character. He produced more than 100 character witnesses, but the judge was very clear, saying, I think the exact words were, if somebody with the character of Pope Francis comes before this court again, he cannot expect leniency. So effectively, I think it's sort of almost one and done on good character. And obviously he showed exemplary good character after this offense with the work he'd done in Ukraine, etc. We had another case in the UK involving a man called Carlos Abarca. He was the CIO at a bank, TSB Bank, and he was meant to be dealing with an IT migration project. He had various board reporting obligations, and he met with the board and he said the program's on track, but it ended up being a disaster, partly because a supplier failed and that supplier was connected with the parent company of the bank. And Abarca himself was fined just under $100,000 after discount. And one of the interesting factors in the regulatory prosecution was his LinkedIn profile. Abarca was effectively trying to say, yeah, but this wasn't all down to me. And they said, in your LinkedIn profile, you said you're a specialist in change, in managing complex programs. So we're going to judge you by that. And that's maybe one of the lessons to be learned from these cases, that If you have, let's just call it an over ambitious LinkedIn profile or resume where you claim to have skills that you don't, be aware of the fact that you will be judged by that higher standard that you have announced for yourself. And then a third case I'd maybe highlight, which is ongoing at the moment, is Tim Brown. He's the CISO at SolarWinds. He was charged by the SEC in October 2023. And effectively, the SEC said that he had overstated SolarWinds cybersecurity practices and understated or failed to disclose known risks. They said that his disclosures were too generic. So he'd say things like, yeah, we could be attacked, rather than talk about the specific threats they had and he knew about. Some of those charges were dismissed in July 24. As far as I understand, the SEC are pursuing others. And they also secured settlements from Unisys, Avaya, Checkpoint, and Mimecast in October 2024 as part of the same investigation. So I think it's watch this space on Tim Brown, but we have a clear direction of travel here. I think, firstly, as I've said, from prosecutors, but also from legislation as well. And if we look at legislation in Europe, like NIS2, like DORA, like the EU AI Act, like the EU Cyber Resilience Act, a common feature of all of those pieces of legislation is looking at personal liability for individuals involved. And that could be the CISO, that could be the CIO, it could be the Chief Compliance Officer. There are also changes to listing rules as well in areas like cybersecurity. And there's also a litigation trend as well, both in Europe, but more so in the US. In cases like Yahoo, in SolarWinds, we've had class actions focused on individuals as well as the corporation. I think it is something that any C-suite officer needs to look at specifically. And I think that there are tips that you could look at in different areas. I think, first of all, if you're interviewing for a new position or you have a headhunter knock on your door, then I think you should do due diligence into the organization that you're walking into. Look at their prior events, look at things like board composition, which we've talked about before. A strong board is likely to be less risky for a C-suite executive, but equally, a board that has deficiencies is likely to be a potential concern, because I think that regulators will the regulators will expect the sort of the professionals to make up the deficiencies caused by those issues in board composition. I think attitude to compliance of the corporation will be very important. Things like looking at their systems that they already have in place will be very relevant, and then also taking a look at their website to see how much they talk about compliance, ethics lines, stuff like that can be part of that due diligence package. I think if you're through the interview process and you're then looking at engagement, then I think there's work to be done there again. I think things like looking at your terms and job description are really important. So is the CCO's job, which it should be, to supervise people doing things for compliance, or are you one of the people that are in the coal face doing stuff? And I think there's always that issue when people blur between ensuring compliance and being responsible for compliance. We see that in areas like data protection. We see that with financial services organizations, for example. So the compliance officer's role is a very special one, and you need to embody that specialness in the job description. I think you need to look at indemnity clauses in your employment contract. You need to look at reporting lines, board access, resources, D&O insurance. And then the last thing I'd say is look out for your remuneration package. If your remuneration package is heavily tied to share price or you're incentivized by stock options, I think you're likely to be more vulnerable to prosecution, just as we saw with things like Martha Stewart in the past, where you're perceived to be incentivized to cover things up that affect the stock price. So watch out for things like that in particular. And then, assuming that all of that's gone and you're accepting a new role, then I think you need to obviously do things like gap analysis in your first 100-day plan, look at board briefings, skills assessments, employee training, rehearsal, and a process of responding to incidents. I think one of the issues that Sullivan said he faced was a board that either knew about stuff or didn't want to know about stuff. And neither of the latter's just not sustainable. And if the board do know about things, then you've got to make sure that it's minuted that they took that risk. Otherwise, you're left out on a limb. So I think it is a real issue for anybody who's going into a new post this year. It's also obviously even more of an issue if you're already in post, because your ability to influence might be not as great. And things like D&O insurance, if you haven't got them when you went into role, it's often hard to negotiate insurance once you're in post. But I think for most individuals, you get peace of mind if you at least go through those processes and see if you can change the situation and protect your personal position as well as that of the corporation.
Jonathan, the Securities and Exchange Commission has a basic formula for CCO liability in the financial sector and other regulated industries, which is CCO can be liable if they are grossly negligent, not negligent, but grossly negligent, meaning really bad, as opposed to just stupid. Number two, if they are a part of the scheme. Or number three, if they essentially engage in conscious indifference or turn into an ostrich and bury their head in the collective sand. I have always found that formula to be a good formula to both protect the public for regulated industries and to delineate to a CCO what their legal obligations could be and how they might violate those. The thing about the Solar Winds prosecution of their CCO that troubled me was essentially that people below the CISO had reported or communicated failures in the data privacy system or data protection system. And these were not sort of formal hotline reports. These were communiques that you would see employees engage in from time to time. It wasn't as bad as TD Bank, where the tellers were saying, "Isn't this money laundering?" But you routinely in a corporation, and I've worked in 50,000 employee plus corporations where I've seen those dialogues and in emails. And I try to communicate to people, don't say stupid things in emails, but people are people and they say stupid things in emails, particularly if they're not lawyers. So that's one. But two is you and I both are hearty advocates for formal reporting of issues, whether that be go see your manager or your supervisor, whether that be send an anonymous email or whether it be pick up the phone calling or pick up the phone and call. Very retro. And so my fear when that case came out was the SEC was using examples of routine corporate, I don't want to even say communication, but dialogue between people. And that could easily move towards you had an issue reported. And that issue was antithetical to your stated position, whether inside the corporation or to external stakeholders. We've got everything under control. And because it's all part of a process. And I wonder if you see regulators moving towards that. And if so, that really does concern me for CCO liability because they're really impinging on and taking away the information flow that every corporate officer hopes their corporation has.
Yeah, I think that's a there's a lot of really valid points there. I think that the email being a perpetual witness to wrongdoing, we've talked about before, but also email can be a source of speculation, not truth. I've just been involved in a large internal investigation where you got hold of documents that suggested that bad things had happened when they hadn't in some cases. Because if something unusual happens, then a lot of individuals in the organization tend to speculate on the cause of it. Sometimes that speculation can be unhelpful. So you're right that we've both talked before about careful communications. We're not saying bury issues, because that's one of the allegations against Sullivan. But we are saying be careful about stuff and talk about facts, not speculations. But at the same time, in most cases, there's one of the issues tends to be that people sit on bad news as well. We've talked about this before, haven't we? That certainly when I was a kid and I was in the Boy Scouts, to get your fireman's badge, you had to go along and they taught you to diagnose the type of fire it was. And then a blue fire extinguisher was going to be on this type of fire, and a red fire extinguisher was this type of fire, and a silver fire extinguisher was this type of fire. And nowadays, we don't tell people that stuff anymore. We say, raise the alarm and get out of the building. And we say that because people delayed action whilst they tried to remember which fire extinguisher to use. And unfortunately, people came to harm along the way. So I think that we're going to see, as part of that, I hope, people be more careful in their use of emails. But the whole reporting piece, I think, is particularly challenging. I know that I've written before about the case of Anthony Wills, who was the compliance officer at Bank of Beirut. It's I don't know whether I've told you the story before, Tom. I wrote an article on the regulatory investigation into him, and he rang me himself. And I thought this was going to be one of those stop writing about me or I'll sue you type calls. And he said, do you want to meet for coffee and hear the other side of the story? And it was fascinating to meet somebody who's been in the crosshairs of a regulator who isn't your client. It's a bit of a different angle. So that whole reporting thing, I think, needs careful thought. And obviously, organizations have to encourage reporting. We've seen cases, I can think of one particular bank, where management asked people to find out who the whistleblower was. And that's a bad thing as well. But once we know of these issues, we can't just bury them and hope they go away. A, because that's likely to expose us to greater liability, and B, because they rarely do go away. You often have to grab these issues. I have got some sympathy with the SolarWinds people, but I guess if I'm the SEC, what I would say is they knew that they had issues with their systems and they didn't confess that, and people bought stock in the corporation and executives benefited from that. So why shouldn't they be held to account for the information which they allegedly withheld from the market?
It's going to be very interesting under the new administration as well. I would anticipate a sort of a rollback of enforcement, but as you correctly noted, they love to go after individuals. So perhaps we'll see more individual liability, but it may kind of cut back to one of the three categories that seem to be the current state, at least under SEC prosecution for financial institution, CCOs. Are things looked at any differently in your jurisdiction?
I don't think so. I don't think so. I think it is that whole, you have got to be grossly negligent in many cases. I know the local adoption of NIS, for example, in some jurisdictions, they're going for that standard and adopting that as well. But equally, in some of these cases, it does look gross negligent. If you're ABC Corp and the passwords for one of your key servers are ABC Corp 123, that probably is gross negligence. And if you're the individual who's chosen that password, or you know that password exists for a key server, probably is gross negligence to cover that up and not do anything about it if that server's then compromised. I think standards like that are always going to be difficult. I'd say one last thing there on that, Tom, is even being acquitted ain't a victory, isn't a victory in these cases. If you look at people like Bank of Beirut guy that I mentioned, more or less unemployable in the European financial services sector, even though the fine was relatively small. Carlos Abarca, the last time I heard, unemployable in Europe, takes a job as a lecturer in Brazil instead. Even for people that have been acquitted, it's life-changing. Even if your legal fees are met, it's still a life-changing event for you. So you don't want to be in a position to be investigated, let alone charged. And so for most people, I think caution is the right way ahead.
That sounds like a great note for us to end this podcast on, Jonathan. I can't wait to see what we can come up with next time.
Absolutely. Thanks again, Tom.